In my contents for educational purposes only. Can't stress enough for you guys to do your own research. Praise my content. Any areas you find, throw in the comments. None of us have been alive long enough to know all that transpired in the past, and none of us can live long enough to know all there is to learn. Okay, this will be part 2 of the UCC connection to our slavery. Yeah, that's the name of it. And yeah, that's it. And I'm gonna be starting at the introduction. What you guys got on the part 1 video was everything leading up to the introduction. And as I said on the last video, this is where it starts getting a little deeper. So, with that being said, I will resume the reading. Okay, introduction. I was asked to testify in a tax case, as an expert witness. After many days of preparation, I felt confident of my research. I spent over 30 minutes presenting many Supreme Court decisions that supported the defendant's position. The prosecution concluded his statements, and to my amazement, the judge told the jury that they could only consider certain facts, none of which were the facts I'd given. As soon as the trial was over, I went around to the judge's office, and he was just coming in through his back door. I said, "Judge, by what authority do you overturn the standing decisions of the United States Supreme Court? You sat on the bench while I read that case law. Now, how do you, a district judge, have authority to overturn decisions of the Supreme Court?" He says, "Oh, those were old decisions." I said, "Those are standing decisions. They have never been overturned. I don't care how old they are. You have no right to overturn a standing decision of the United States Supreme Court in a district court." Okay. The next portion is labeled Public Law versus Public Policy. I'm assuming that they're about to get into the differences between the two. So, I'll find out when you do. We're going to find out together. Together. Yeah. All right. He said, "Name any decision of the Supreme Court after 1938 and I'll honor it. But all the decision you read were prior to 1938, and I don't honor those decisions." I asked what happened in 1938. He said prior to 1938, the Supreme Court was dealing with public law. Since 1938, the Supreme Court has dealt with public policy. The charge that Mr. S was being tried for is a public policy statute, not public law. Y'all hearing this? See? And those Supreme Court cases do not apply to public policy. I asked him what happened in 1938. He said that he had already told me too much. He wasn't going to tell me anymore. Okay. Amen. Take the free game, man. Look the shit up. I'm pointing this shit out for y'all. But I mean, like, I'm not going to do it for you. You know. I'm sharing this with you because this is the first time I'll be reading through this entire document. So I'm sharing it with you guys as I'm learning of it myself. This is why you'll hear me stop and make reference to you guys jotting these things down, so that way you will be abreast after you research it further. The next portion is labeled 1938 and the Erie Railroad. Again, as I stated in the last video, any of us that have been incarcerated or remanded to the custody of the state and have visited any law library, I'm pretty sure you've come across this case in your research. Well, I began to investigate. I found out that 1938 was the year the Erie Railroad versus Tompkins case of the Supreme Court. I found out that 1938 was the year of the Erie Railroad versus Tompkins case of the Supreme Court. It was also the year the courts claimed they blended law with equity. Okay. I read the Erie Railroad case. A man had sued the Erie Railroad for damages when he was struck by a board sticking out of a boxcar as he walked alongside the tracks. The district court had decided on the basis of commercial, and then it has in parentheses, negotiable instruments law, commercial law. Okay? That this man was not under any contract with the Erie Railroad, and therefore he had no standing to sue the company. Under the common law, he was damaged and he would have had the right to sue. You understand what they did? That paragraph right there lets you know that under commercial law, which is what we are now under, Uniform Commercial Code, all right, it states that you have to be under contract with any corporation in order to have standing to sue said corporation. As the courts no longer deal with common law. Again, the corporate United States. Can the United States stand across the courtroom and say that you damaged it? No, it cannot. Can it appear in court and speak for itself? No, it cannot. I hope y'all understand, and I'm pointing these things out so you can kind of grasp what it is that they refer to as the Matrix. They don't go this deep because, again, you got to read and research for yourself. Anyway, let me go on, continue with the reading. This overturned a standing decision of over 100 years. Swift versus Tyson in 1840 was a similar case, and the decision of the Supreme Court was that in any case of this type, the court would judge the court would judge the case on common law of the state where the incident occurred, in this case, Pennsylvania. But in the Erie Railroad case, the Supreme Court ruled that all federal cases will be judged under negotiable instruments law. There will be no more decisions based on the common law at the federal level. So here we find the blending of law with equity. This was a puzzle to me. As I put these new pieces together, I determined that all our courts since 1938 were merchant law courts, not common law courts. That's what I was just pointing out to you. Merchant law. What is that? That is the law of the sea. Maritime law. Okay? And it's a deeper story to that. I have to do a video on it one day because I also have the Book of the Sea. All right? Okay. There were still some pieces of the puzzle missing. Okay. The next heading of the next paragraph is labeled a friend in the court. Goes on to say, fortunately, I made a friend of a judge. Now, you won't make friends with a judge if you go into a court like a wolf in black sheep country. You must approach him as though you are the sheep and he is the wolf. I'm going to read that again for y'all because it's important that y'all grasp this. It's very, very important that you grasp this. This is a prime example of the 48 Laws of Power, where it says never outshine the master. Okay? It says, pardon me, yeah. All right. Fortunately, I made a friend of a judge. Now, you won't make friends with a judge if you go into a court like a wolf in black sheep country. You must approach him as though you are the sheep and he is the wolf. If you go into court as a wolf, you make demands and tell the judge what the law is, how he had better uphold the law or else. Remember the verse, I send you out as sheep in wolf country. Be wise as a serpent and harmless as a dove. We go into court and be wise and harmless and not make demands. I misread that. We have to go into court and be wise and harmless and not make demands. We must play a little dumb and ask a lot of questions. Well, I asked a lot of questions and boxed the judges into a corner where they had to give me a victory or admit that they didn't want what they didn't want to admit. I won the case. And on the way out, I had to stop by the clerk's office and get some papers. One of the judges stopped and said, "You're an interesting man, Mr. Freeman. If you're ever in town, stop by. And if I'm not sitting on a case, we will visit." Okay, the next topic for the next paragraph, is labeled America is bankrupt. I've been saying that. Anybody who watches these videos that I post on YouTube, you can quote me saying that several times, if not a dozen. A lot of people don't, see again. This is where what's the name of that the phrase? I did a video on it and everything. Cognitive dissonance. For those of us who only know what our conquerors have taught via their sanctioned, owned, controlled, and operated curriculums, we don't want to even deal with things that go against what we've been, conditioned to believe. And whether you believe you've been conditioned or not, you need to do some research on the government programs that they've ran. All you got to do is look them up. America is bankrupt. Later, when I went to visit the judge, I told him of my problem with the Supreme Court cases dealing with public policy rather than public law. He said in 1938 that all the higher judges, the top attorneys and the U.S. attorneys, were called into a secret meeting, and this is what they were told. America is a bankrupt nation. It's not a nation either. That's another thing. Nations don't have presidents, contrary to popular belief and opinion. I'm going to read as it reads anyway. America is a bankrupt nation. It is owned completely by its creditors. Key word, creditor. The creditors won the Congress. They won the executive. They own the judiciary. The judiciary. They won all the state governments. Yeah, this is what they're not going to teach you in those said curriculums. I guarantee. Okay. Take silent judicial notice of this fact, but never reveal it openly. Your court is operating in an admiralty jurisdiction. Call it anything you want, but do not call it admiralty. Okay. Speaking of it, that is the next topic for the next about two and a half paragraphs. Admiralty courts. The reason they cannot call it admiralty jurisdiction is that your defense would be quite different in admiralty jurisdiction from your defense under common law. In admiralty, there is no court which has jurisdiction unless there is a valid international contract in dispute. If you know if you know it is admiralty jurisdiction, then they have admitted on the record that you are in admiralty court. You can demand that the international maritime contract to which you are supposedly a party and which you supposedly have breached be placed into evidence. Very important information, people. Very important information. I'm going to go on and read, though. No court has admiralty maritime jurisdiction unless there is a valid international maritime contract that has been breached. So you say, just innocently like a lamb? Well, I didn't know that I got involved with an international maritime contract, so in good faith, I deny that such a contract exists. If this court is taking jurisdiction in admiralty, then pursuant to Section 3-501 of your UCC, Uniform Commercial Code, and it has presentment in parentheses. That's another legal term, presentment. It's basically an assumption. Left unrebutted, it stands. I'm hoping that y'all can grasp this. I'm speaking in the, baseboard terms, plain English, Okay. The prosecutor will have no difficulty placing the alleged contract into evidence so that I may examine it. No, let me take it back to the beginning of that sentence so it won't sound, it kind of like didn't sound right. It says, if this court is taking jurisdiction in admiralty, then pursuant to Section 3-501 of your UCC presentment, the prosecutor will have no difficulty placing the alleged contract into evidence so that I may examine and possibly challenge the validity of the contract. What they would have to do is place the national debt into evidence. They would have to admit that the international bankers own the whole nation and that we are their slaves. I just want y'all to not dissect, but digest that for a minute. I'm going to read it again. What they would have to do is place the national debt into evidence. They would have to admit that the international bankers own the whole nation and that we are their slaves. Okay. The next section is labeled not expedient. But the bankers said it is not expedient at this time to admit that they own everything and could foreclose on every nation of the world. Do you hear that? Let me stay on task. Let me control myself and my emotions and all of that. Because personally, man, I just feel like, if this shit don't piss you the fuck off, okay, let me start that over. Not expedient, but the bankers said it is not expedient at this time to admit that they own everything and could foreclose on every nation of the world. The reason they don't want to tell everyone that they own everything is that there is still too many privately owned guns. I told y'all. Be a person of peace, but please prepare to defend your inalienable, God-given rights to live, to breathe, to be unencumbered, to defend yourself and your loved ones. Yeah, I feel like this is one of the most important videos I've done thus far on this channel, man. But let me get back to it, man. I ain't gonna blab on. I don't be liking that when I'll be watching other people's video and they get to talking nonsense. They just interrupt the information. So let me get back to it. The reason they don't want to tell everyone that they own everything is that there are still too many privately owned guns. There are uncooperative armies and other military forces. So until they can gradually consolidate all armies into a world army and all courts into a single world court, it is not expedient to admit the jurisdiction the courts are operating under. When we understand these things, we realize that there are certain secrets they don't want to admit, and we can use this to our benefit. Let me just point out to y'all, I'm not getting this from a video. I have documentation, okay? I have documentation, pounds of it, Not coming from an egoistic perspective, just pointing that out, because if you don't have a foundational basis of knowledge to operate from and to make decisions from, and you're going off of strictly videos, you gotta understand, people, we don't control information. We haven't rewritten history. We haven't graduated from lab rats to humans, doing test runs and trials on, experimental medications and things that they just created, to see how it would affect people and to see if it was usable for a profit. Do the math, man. Do the math. So what I'm saying is, Kiss, shout out to Kiss, man. You want to hide something from a nigga, put it in a book. You put it in a bag, they gonna try it. You niggas can't deny it. Anything the government done produced and brought forth to the public, you got millions of individuals jumping on it head first. Just like that joke I made in History 101 Part 2. It's the video that's on the page as soon as you come on the page. Oh, they said, master, they said this tastes good on bread. It's brown, stinking. They tell you to eat a shit sandwich and it's gonna taste good. I bet you a bunch of motherfuckers will be eating shit sandwiches. I guarantee. It was funny when I said it, but this shit's so real. All you gotta do is look around you. Look around you. Everybody trying to follow the followers, man. Everybody trying to do what they see the politicians doing. You dig? Anybody that's in an organization anyway, from my experience and observation and analyzation, don't you bend over and spread your ass cheeks for nobody. Because that's basically what you're doing when you allow people to just do you any kind of way. And then as the government does, hide their hand. and ask you what the fuck's wrong with you. Shaking their dick over top of your head, talking about, yeah, that was a hell of a thunderstorm. You know, did you get caught out in that? Don't let nobody insult your intelligence, man. You play fool just long enough to catch a fool. Anyway, back to the script. All right. The next part is jurisdiction. The Constitution of the United States mentioned 3 areas of jurisdiction in which the courts may operate. Number 1 is common law. Common law is based on God's law. Anytime someone is charged under the common law, there must be a damaged party. What I say? Can the United States, can the state of Delaware, can the county of Newcastle stand across from you in the courtroom and point its finger at you and say he or she damaged me and or my property? I suffered damage or I suffered a financial loss based upon his or her actions? Hell no. Why? Because it's a corporate entity. It's a corporate person. The same thing as your name in all capital representation of what looks like your name. Straminius Homo. I've did these videos, man. I just hope y'all paying attention. This shit is real. Please believe it. You ain't got to. You know, you came out the womb by yourself. You're going to have to make decisions for yourself. And you're going to ultimately, this flesh is going to eventually perish. And the true essence of what and who and what you are is going to go on to another phase of existence. By your lonesome. Okay. Common law. Common law is based on God's law. Anytime someone is charged under the common law, there must be a damaged party. You are free under the common law to do anything you please so long as you do not infringe on the life, liberty, or property of someone else. Let me read that again. This is why they got away from it. Because they wouldn't be able to do the shit that they've been doing under common law. And this is why it's been a secret, which equates to what? Fraud. And I want to correct a mistake that I made on an earlier video. There are 7, not the and I need to do that over that contract video because I took poor notes and I probably kind of confused a few people with the way I presented it. So I'm gonna do a new one and clear those things up. But like I was saying, they wouldn't be able to perpetrate these frauds in this outright what do they call that? They basically what do you call the word? They basically raping us, man. In no uncertain terms, man. No uncertain terms. I can't think of the word I want to use at this point, but anyway. It says, you are free under common law to do anything you please, as long as you do not infringe on the life, liberty, or property of someone else. You have a right to make a fool of yourself provided you do not infringe on the life, liberty, or property of someone else. The common law does not allow for any government action which prevents a man from making a fool of himself. For instance, when you cross over the state lines, in most states, you will see a sign which says, buckle your seatbelts. It's the law. This cannot be common law because who would you injure if you did not buckle up? Nobody. This would be compelled performance. And this is why I say, all that freedom talk y'all jokers be spitting, say that shit. Save it for David. It's compelled performance. But common law cannot be compelled performance. Any violation of common law is a criminal act and is punishable. Hope y'all getting this. The second type of jurisdiction is equity law. Equity law is law which compels performance. It compels you to perform to the exact letter of any contract that you are under. So, if you have compelled performance, there must be a contract somewhere, and you are being compelled to perform under the obligation of the contract. Now, this can only be a civil action, not criminal. In equity jurisdiction, you cannot be tried criminally, but you can be compelled to perform to the letter of a contract. If you then refuse to perform as directed by the court, you can be charged with contempt of court, which is a criminal action. Are our seatbelts laws? Equity laws. No, they are not, because you cannot be penalized or punished for not keeping to the letter of a contract. Let me read that again. Okay. Are seatbelts laws, equity laws? No, they are not, because you cannot be penalized or punished for not keeping to the letter of a contract. Third type of jurisdiction is admiralty maritime laws. This is civil jurisdiction of compelled performance, which also has criminal penalties for not adhering to the letter of the contract. What contract? What contract? I hope y'all been paying attention. You should know what contract, but I'm going to read on. But this only applies to international contracts. Now we can see what jurisdiction the seatbelt laws, all traffic codes, etc. are under. Whenever there is a penalty for failure to perform, such as willful failure to file, there is admiralty maritime law, and there must be a valid international contract in force. It didn't say shall, it said must, in bold lettering. However, the courts don't want to admit that they are operating under admiralty maritime jurisdictions, so they took the international law or law merchant and adopted it into our codes. I told y'all, codes, statutes, and regulations are not law. This is what the Supreme Court decided in the Erie Railroad case, that the decisions will be based on commercial law or business law, and that it will have criminal penalties associated with it. Since they were instructed not to call it admiralty jurisdiction, they call it statutory jurisdiction. Okay, courts of contract is the next portion. You must ask how we got into this situation where we can be charged with failure to wear seatbelts and be fined for it. Isn't the judge sworn to uphold the Constitution? Yes, he is. But you must understand the Constitution. In Article 1, subsection 10, gives us the unlimited right to contract, as long as we do not infringe on the life, liberty, and property of someone else. Contracts are enforceable, and the Constitution gives two jurisdictions where the contracts can be enforced: equity or admiralty, but we find them being in statutory jurisdiction. This is the embarrassing part for the courts, but we can use this to box the judges into a corner in their own courts. We will cover this more later. Contracts must be voluntary, meaning no threat, duress, or coercion. Meaning you can't be forced to perform under threat of being arrested, thrown in jail, fined, getting points on your license, making your life a little more harder, a lot more harder. And then the way insurance is, they might have you try to have you paying $600-700 a month in insurance. There's ways around that, but y'all gotta get your study on. Y'all gotta get your research on. Learn your rights so you can enforce your rights on these puppets, these puppeteers. Okay. These agents. Think the Matrix movie. The dude with the glasses. Yeah, him. And all the other ones. Yup. Okay. Contracts must be voluntary. Under the common law, every contract must be entered into knowingly, voluntarily, and intentionally by both parties, or it is void and unenforceable. These are characteristic. It must be based on substance. For example, contracts used to read for $1 and for $1 and other valuable considerations, I will paint your house, etc. That was a valid contract. The dollar was a genuine silver dollar. Now, suppose you wrote a contract that said, for one Federal Reserve note and other considerations, I will paint your house. And suppose, for example, I painted your house the wrong color. You could go into a common law court and it says, could you go into a common law court and get justice? No, you could not. You see, a Federal Reserve note is a colorable dollar. That means it's not a real dollar. It only has the semblance of a real dollar. Okay. A Federal Reserve note is a colorable $1, as it has no substance. And in a common law jurisdiction, that contract would be unenforceable. Colorable money colorable courts is the next section that it goes into, and it's about 2 paragraphs. Okay, it says the word colorable means something that appears to be genuine but is not. Maybe it looks like $1, maybe it spends like $1, but if it is not redeemable for lawful money, silver or gold, it is colorable. If a Federal Reserve note is used in a contract, then the contract becomes a colorable contract, and colorable contracts must be enforced under a colorable jurisdiction. So by creating Federal Reserve notes, the government had to create a jurisdiction to cover the kinds of contracts which use them. We now have what is called statutory jurisdiction, which is not a genuine admiralty jurisdiction. 1, colorable, that which is in appearance only and not in reality. What it purports to be, hence counterfeit, feigned, have the appearance of truth. Black's Law Dictionary, 6th edition. It is colorable. Admiralty jurisdiction, the judges are enforcing because we are using colorable money. Colorable admiralty is now known as statutory jurisdiction. Let's see how we got under this statutory jurisdiction. Uniform Commercial Code is the next section. 2 paragraphs. The government set up a colorable law system to fit the colorable currency. It used to be called the law merchant or the law of redeemable instruments because it dealt with paper which was redeemable in something of substance. But once Federal Reserve notes had become unredeemable, there had to be a system of law which was completely colorable from start to finish. This system of law was codified as the Uniform Commercial Code and has been adopted in every state. This is colorable law, and it is used in all the courts. I explained one of the keys earlier, which is that the country is bankrupt and we have no rights. If the master says jump, then the slave had better jump because the master has the right to cut off his head. As slaves, we have no rights, but the creditors/masters have to cover that up. So they created a system of law called Uniform Commercial Code. This colorable jurisdiction under the Uniform Commercial Code is the next key to understanding what happened. Okay? I'm going to leave it there. I'm going to read through the whole thing, but I'm going to leave it there for this video. All right? I hope y'all was paying attention. As is my intent every time I do a video, I hope that somebody could derive some benefit out of this information that I dispensed. And I hope that you guys take notes, all the things that I, bring attention to, you write it down and look it up for yourself so you can see what it is that I'm actually saying to you. So with that being stated, y'all be easy.